So the Supreme Court has relisted the challenges which aim to strike down assault weapon and magazine bans nationwide. So let's break down what is happening. Now, really quick before we jump into this video, I want to ask you guys for a huge favor. Looking at some of my analytics, about 58 to 60% of all viewers are actually not subscribed. So if you want to support the channel, please consider subscribing. We're headed towards 800,000 subscribers, and I would love to do that. Never would have thought we would actually reach that here on the channel. So if you want to do that, support the channel. Also, just drop a positive comment here on this video, because that helps to tell the algorithm that you enjoy this content and it should share it to more people. As I mentioned in the intro, in this video, we're going to be talking about some very important developments in a couple cases which are challenging various state bans on so-called assault weapons and then also magazine restrictions as well. The critical cases we're going to be talking about are Snope versus Brown and then also Ocean State Tactical. We've been keeping our eyes on these two cases because the Supreme Court has relisted them multiple times for conference, and we were hoping that the court would grant review to at least one of them so that we could actually have a decision issued on this critical issue and potentially strike down statewide bans on magazines and rifles pretty much nationwide, using these two cases as a vehicle to then go after other state bans. Now, unfortunately, the Supreme Court did not do that at the end of their last kind of consideration, so it doesn't seem like they're going to hear and decide on this issue this term, but the cases were not denied review. They've been relisted multiple times. The last conference was last Friday, and so we talked about how we were going to be keeping our eyes on the order list this Monday, and we got the order list. And unfortunately, once again on the order list, there was a relisting of these cases. Now, the good news is that they were not outright denied, so that's a positive, but we need to talk about what is happening now with the multiple relists. Now, for those not aware, one of the critical cases is Snope, and it's kind of the biggest case because it deals with a state outright banning so-called assault weapons. And this case was prior in front of the Supreme Court, and it was GVR, meaning that it was granted, vacated, and remanded by the Supreme Court after Bruen. Now, this case, Snope, involves the state of Maryland's ban on assault weapons and defining, pretty much these so-called assault weapons with various characteristics, trying to identify them as these dangerous items and then therefore restricting them within the state. The ban was challenged in a federal district court in Maryland. However, this case was dismissed by the lower court because there was already a case on the books there that found that the Maryland ban did not violate the Second Amendment. Now, this case, Snope, conceded that Colby was the controlling precedent, but it argued that it was incorrect and should be reversed. The dismissal in this case was appealed to the Fourth Circuit, and the Fourth Circuit upheld that dismissal, and then that led this case for the first time to make its way to the Supreme Court back in 2022, seeking Supreme Court review of this issue. Now, the Supreme Court ultimately ruled in the landmark Bruen case in a 6-3 decision, and then after that, GVR'd this case back down to the Fourth Circuit for a new decision in light of Bruen. Now, this case was opened back up in the Fourth Circuit and was heard and argued back in December of 2022, but then suddenly, after it sat for 13 months, the Fourth Circuit en banc panel decided they wanted to take this case out of the hands of the 3-judge panel and issue their own decision. And really, they did that because they did not want a pro 2A decision coming out of their jurisdiction. And as a result of that, the Fourth Circuit en banc panel ruled in favor of this Maryland ban. In the decision, the Fourth Circuit upheld the state's ban using the incorrect military use test. Essentially, the Fourth Circuit believed that AR-15s are useful in military service, and because of that, they can be restricted by a state. Now, as a result of that horrible decision, the Snope case is now once again seeking Supreme Court review. And since it's a final merits challenge and it's dealing with the constitutionality of these rifle bans, it's one of the more important challenges that we have going on right now, and it's in front of the Supreme Court. The Snope case was originally set to go to conference back last December, but then it was rescheduled, not relisted. It was rescheduled, and it was set for January 10th. Now, since January 10th, it has been relisted multiple times. The most recent one was last Friday. It went to conference last Friday, and then on this order list, we actually got no statement on the cases at all. So they were not granted review, they were not denied review. We didn't get any really indication. Instead, they were relisted for this Friday, February 28th. Now, the other case is the Ocean State Tactical case, and in that case, the plaintiffs challenged the state of Rhode Island's magazine ban. And ultimately, the lower court denied the preliminary injunction that was requested in that case. Now, Unlike the Snopes case, the Ocean State Tactical case here is an interlocutory challenge. It's still in an interlocutory posture dealing with a preliminary injunction, but it does deal with magazine bans and a state restricting access to those magazines. Now, the Ocean State Tactical case has been kind of trailing with the Snopes case, and once again, it has been set for conference this Friday along with Snopes. Now, you may be asking yourself, what is going on with all these relists, and why is the Supreme Court relisting these cases so important for the outcome of what could happen? Well, that's because all the Supreme Court analytics and tracking on prior cases show that a case has a higher odds of being granted review by the Supreme Court if it's relisted at least one time. In fact, according to the data, for the court's 2016 to 2020 terms, between 31% and 43% of all petitions that were relisted at least once were eventually granted review. So the analytics show that a case being relisted at least one time makes it a far better chance of being granted review by the Supreme Court. But there's also data that shows that multiple relists is not really a good thing. And that's kind of what's happening with the Snopes and Ocean State Tactical case. Typically, that could be a bad sign. Multiple relists often indicates that a case is going to be denied review and that maybe you're going to get a dissent from maybe one or more judges. For example, in 2022, only 28% of all cases were granted review after 2 relists, and that percentage drops even further when it's 3 or more relists, like what's going on here in these challenges. There is still a chance that a case could be relisted multiple times and granted review by the Supreme Court, but the odds are not great. So where does this data and developments in these cases kind of leave us? Well, the first domino, like I mentioned, has fallen in a prior case, Gray versus Jennings. Now, that case also dealt with magazine bans and it was an interlocutory posture, but the Supreme Court denied review of those cases after the January 10th conference. However, since then, the Supreme Court did not outright deny the Snopes case or the Ocean State Tactical case. They've relisted them multiple times, so that could be a good sign. If they were just going to deny review, they could have just outright denied them like they did with the Gray versus Jennings case. However, now with multiple relists, the odds are kind of moving more and more towards potentially Supreme Court denying review in these cases. The multiple relists could be a product of maybe dissents being written by Justice Thomas or Alito who are unhappy with the denial of these cases. However, interestingly, the fact is that in today's order list, there were multiple cases that were denied review, and there were dissents from judges like Thomas and others. So if you wanted to draw maybe a positive conclusion from today's order list, that could mean that if they were going to deny them and maybe write a dissent, that was the purpose opportunity this Monday because they did that in other cases. So maybe there's an indication that Snopes and Ocean State Tactical are moving forward and they're not going to be denied and there's not going to be those types of dissents. Now, there's always an outside chance that multiple relists is a product of maybe heightened interest in these cases, or simply that the court is wanting to push these cases out to a later review. For example, the most recent landmark Second Amendment case, New York State Rifle and Pistol Association versus Bruen, that case was relisted for conference 4 times before it was granted review by the Supreme Court. Also, the Cargill bump stock challenge was relisted 4 times before it was also granted review. So if you're looking at some of the other Second Amendment cases that kind of face similar multiple relists, those cases were relisted 4+ times and eventually still granted review by the Supreme Court. Now, my gut is telling me and maybe preparing me for these cases to be denied review, maybe with some dissent, but my heart is ultimately hoping that these will be granted review and maybe the Supreme Court is just trying to buy some time and is just delaying these cases and maybe pushing them out for a later period. There's also always the outside chance that something strange could happen, like a per curiam opinion, which is simply a short and quick opinion of the court. There's no dedicated author, but simply the court saying, hey, we think these laws are clearly unconstitutional and they need to be struck down. But I think the higher probability of what is happening right now is that the court is pushing these cases out. There's also maybe some interest in delaying these cases until some of the other Second Amendment issues are resolved with the whole Trump transition and the executive order that he's issued and the new attorney general and the new ATF director and all the things that are going on. So maybe the Supreme Court is still pushing these out for a later date until some of these other things are resolved. So these cases are entering still a very critical stage. All eyes will be on the Supreme Court again this Friday for the relist in these conferences. And then we're going to be watching next Monday as well for the order list to see what they do. And we're going to be crossing our fingers, at least hoping that they're not denied review and we don't see a dissent. At the very least, maybe we want a relist, but ultimately what we really want is a grant and review in these cases. So again, important battles. We're going to be keeping our eyes on these. As things develop, as anything else changes, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. So as always, thank you guys for watching. Don't forget to like, comment, subscribe, and never forget this nation was built by ARM scholars, and this nation will be maintained by ARM scholars.